Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Jana, Seidl, and today's episode asks, what's new in antitrust and tech? Unpacking the United States v. Apple. On March 21st, 2024, the United States Department of Justice and 16 attorneys general sued Apple, alleging that, quote, Apple undermines apps, products, and services that would otherwise make users less reliant on the iPhone, promote interoperability, and lower costs for consumers and developers, end quote. In other words, many of the DOJ and AGs allegations boil down to the concept of lock-in, and that is that the features chosen by Apple lock in developers and users to stay in Apple's ecosystem by making it harder to switch or jump between platforms. Some examples the complaint gives involve cross-platform messaging, smartwatches, and digital wallets. Today, we'll be talking more about the case and the claims advanced and what it might mean for antitrust enforcement, tech, and consumer experiences. My co-host is Barry Nigro. Barry, would you like to introduce today's guest?
Absolutely. We're joined today by Stephen Calkins. Steve is professor of law at the Wayne State University Law School, where he teaches antitrust and trade regulation, consumer law, and torts. Steve has also served as associate provost. He's worked in private practice. He's served as general counsel of the Federal Trade Commission and as a commissioner at the Irish Competition and Consumer Protection Commission. And finally, Steve has served 9 years on the council of the American Bar Association Antitrust Law section. Welcome, Steve.
Thank you, Barry. Pleasure to be here and a great honor to be on this wonderful podcast.
So we're excited to have you. Jana gave us the headline of the United States antitrust case against Apple. Can you provide us with a little more detail? What's the case about and what are the causes of action?
I can do that, but I need to start with a disclaimer. Usually folks come on and say, I have consulting and clients and all this, and I'm thrilled to tell you that I do no consulting and have no clients, and am free to say whatever I want. But I think I need to tell you that I have never owned an iPhone. I've got 8 siblings. They all own iPhones. My wife owns an iPhone. My daughter is an iPhone. It's only my 2 tech-oriented sons and I that are in the Android world. So I need to apologize if I'm missing some of the magic karma of the iPhone universe because I've never experienced it. I only know what I read and am told. But I have read the complaint, and the complaint in a way is pretty simple. It alleges monopolization and attempted monopolization of the smartphone market. It alleges monopolization and attempted monopolization of something called the performance smartphone market. And it alleges violations of each of the New Jersey and the Wisconsin state antitrust laws. And that's the case. In terms of what's it about, it's a frontal assault on Apple's way of doing business. So it's about as big deal as you can get in the world of antitrust.
So I noticed that the complaint references the Microsoft monopolization case that was filed back in 1999 by the Department of Justice. And that's interesting because it suggests that Apple's success started with the iPod, due in part to the interoperability with Microsoft's Windows PC, and notes that Microsoft at the time was under a DOJ consent decree that required interoperability. Is DOJ's case against Apple just a sequel to DOJ's earlier Microsoft case?
It's fascinating to see the way that the Justice Department has wrapped itself in the cloak of the Microsoft case. Microsoft was about the high water mark for monopoly enforcement in court by the Justice Department. And there's no question that's the way that the current Justice Department wants people to think about this. When you look at the statement made at the press conference, AAG Cantor said The Justice Department has an enduring legacy of taking on the biggest and toughest monopolies in history, and references Standard Oil, AT&T, and Microsoft. Today, we add to that distinguished legacy. And he goes on and says, approximately 25 years ago, the Justice Department and state attorneys general announced a case against a different platform monopolist. And then he concludes, today we stand here once again to protect competition and innovation for the next generation of technology. They are all about doubling down on Microsoft. Microsoft, indeed, it's mentioned 26 times in the complaint.
So we talked about lock-in and interoperability. It's one of DOJ's main complaints, the restrictions that Apple's imposed on interoperability. Is Apple obligated to facilitate interoperability with the iPhone? I mean, after all, if users are unhappy about the restrictions, what's preventing them, like yourself, from voting with their feet and using Android?
Great question. Very difficult. As a general matter, as you both know, even a monopolist is not obligated to do business with the people they don't want to sell to. So that you can go take Taylor Swift, and if she doesn't want to have her songs on Spotify, she's allowed to say, I'm not going to do business with Spotify. Even a monopolist has the right to say, I'm not going to deal with you. I'm not going to deal with you. And this is how I want to do business. But there are caveats and there are exceptions. And a good example comes in the complaint where the complaint is talking about the smartwatch. And the complaint alleges that in the beginning, the iPhone was allowed to link to other people's smartwatches. Then suddenly Apple brought out its own smartwatch and it changed the rules and said, now we will not do business with the other smartwatch manufacturers. Well, that's starting to look a little more like making decisions, not because it's competition on the merits, not because it is something that is beneficial for the experience, but because it's trying to prevent competition. And if it goes too far in that direction, that can end up being a monopolization violation. I mean, you said that here the customers can simply walk with their feet. Well, back in the Microsoft case, I listened to the oral argument, you may have too, and the argument by Microsoft was that the alternative was just a click away, was what they said, just a click away and you could get to another browser. That did not successfully persuade the court, with the court saying, well, we are going to look at business realities and just how easy is it for people to walk away. Well, as part of my research for this program, I did reach out to my siblings, and I can tell you that one of my brothers responded, and I quote, at this point, I don't think I can leave Apple since my photos and contacts are all there. So you can say he could walk away, but he's not about to. And the question is whether that's a good thing because Apple's doing a good product that people like, or is it a bad thing because of anti-competitive activities? It'll be a great case to watch unfold.
Yeah, and I think we'll get to kind of how users feel about the benefits that flow from a closed ecosystem a little bit later. But I want to follow up on the legal framework that we're looking at, right? And it's no secret that AAG Cantor believes that antitrust enforcement has been too lax. Do you think existing case law is up to the task, or will DOJ need to push the boundaries to win this case?
Boy, that is a very tough question. And there are two parts to the answer, I think. One part, you know that monopoly violations, in a way, are sort of simple. Simply show monopoly power and then show some kind of wrongful conduct associated with that power. Sort of it's two parts. And looking at the second part, is this something where the standard currently in place works? And I think the answer is that it works pretty well. The case law says, is this competition on the merits? Is this legitimate competition? And that's very fact specific, but it'll be fought out, and it's a workable standard. Indeed, when you look at a more refined version of the standard, you look at whether Apple is sacrificing profits today to make monopoly profits in the future or to preserve monopoly profits. And the complaint embraces that somewhat, that standard that's considered a somewhat pro-defense standard, the complaint embraces that and adopts it. So I think on the standard part of this whole thing, it's all going to work and we'll be able to have a case that goes to the merits. The interesting wrinkle for me is the first part, which is monopoly power. And there, the classic sort of standards that you see in the case law is to look in a meaningful way at the market share of the firm involved. And it is normally thought that market shares below 50% are not going to be enough for a plaintiff to win a case. Above 70% will be enough for the plaintiff to win the case. But between the two, it's rather iffy, and you'll find different courts taking different approaches and giving different attention to things other than market share. And there certainly is going to be a strong argument from Apple that they do not have market power under the standard U.S. antitrust law. And you can just know that the enforcers will be looking across the Atlantic Ocean to where I used to work. And it's not a monopoly standard there. The standard is abuse of dominance, and abuse of dominance can be shown at a meaningfully lower market share level than in the U.S. And so one question will be, will that part of the case play out in a way that appears to be doing the right thing in terms of resolving the dispute? And I don't know the answer to that.
Can I go back to the interoperability issue? Because I find that one interesting. It's one thing to say as a matter of legal principle that you need to allow for interoperability. But let's say Apple does at some level allow for that. There are lots of degrees of interoperability. For example, does Apple or a monopolist for that matter, do they have to provide, I'll use a term that goes back to the AT&T cases, equal access? If Apple wants to come out with a smartwatch as they have, do they need to sort of sit on that until they've designed the operating system to interconnect with any other smartwatch? Let's say, I mean, is interoperability need to be implemented in a way that slows innovation? I mean, how does it work in practice? I mean, it sounds good in concept, but it's not clear to me how that works in practice.
You're struggling with hard questions, Barry, and there's going to be a whole lot of fighting about this. Apple, it's interesting, the time that we are in as a country right now, when there is massive concern up on Capitol Hill and around the states about privacy and data security and all this sort of stuff. And the image comes to mind of the person who is going to the cancer treatment center and using their phone to get there, or going to an abortion clinic, or going to anywhere that they want to keep secret. And who can find that out? Who can buy that data? What can they do with it? It's just a huge question for the consumer world and the competition world. And I have no doubt but that Apple will say that their number one concern is protecting their consumers and keeping their consumers safe, and all of their restrictions go to this kind of privacy interest, the privacy concern. And the government is going to come back, I'm assuming, and saying that's nonsense. It's a bit of a facade, and it's really all about protecting the monopoly profits. There's no question but that if Apple can tell a convincing story about why it has some of these restrictions, it is going to be in a pretty strong position. And indeed, it's been making that argument for a long time. They have had good antitrust lawyers who have been counseling them, and they know this issue is going to be out there, and they'll be making the case. And I just, it's hard to know from the outside whether or not they will be successful. But if the government can show that this is all about simply protecting profits, and in particular of Apple turning down things that would be today beneficial to their bottom line, today be beneficial to consumers, all to preserve their power, well, then the government will have a better case. But it's going to be fascinating.
Yeah, and ultimately, I guess a court gets to decide that, right? And so interestingly, this case was filed in New Jersey, which is less convenient for the DOJ litigation team than the courts in Washington, D.C. or EDBA, right, the Eastern District of Virginia, where the other big tech cases are pending. Steve, do you have any thoughts on why DOJ may have opted for New Jersey? Is it possibly due to favorable Third Circuit case law, monopolization issues there?
I love these questions. They come up each time a case is filed. It used to be that cases would routinely be filed in a logical place, as in Washington, the home of the government, or maybe the home of the defendant or someplace that made sense. And yet you can see that that does not always happen. And you know, because we've worked in the government, that any government enforcer thinks about where to go. Well, one of the things you think about is, who are you likely to get as a trial judge? So let's just go up and ask yourselves, who are the trial judges up in New Jersey? And the answer is that in the District Court of New Jersey, there are 15 Democrats and only 2 Republicans, both appointed by the first President Bush. You don't have a whole lot of experienced conservative judges on the district court, and you don't have a lot of Trump judges on the district court who might have some approach that you are not keen on if you're the prosecutor. So I suspect they like the district court. They may like service of process getting into New York. They like the East Coast convenience. They can avoid the Ninth Circuit, which has already had a decision ruling in favor of Apple on the antitrust part of the whole thing. And as you note, they get into the Third Circuit. The Third Circuit is it's not a liberal circuit if you look at the makeup of the judges, but it's not a conservative circuit. And they do have some interesting pro-plaintiff antitrust cases that have come down on the more liberal side. So you go back and you think about the LePage's case, that would be a plaintiff case. And then they decided a monopoly case for the Justice Department, the Dentsply case. And I don't know, were we going back on this question of market power and monopoly power and things when I was talking about these different levels and whether we are below 50% or above 70%, and where do you go there in the middle? Well, if you go and look at the Dentsply case, the Dentsply case says that what is needed, so this is the Third Circuit Court of Appeals, the Dentsply case, that what is needed is a share significantly larger than 55% has been required to be established. But note, it's not saying a share significantly larger than 65% or 70%, and it talks about things other than share. So you take that and you compare it to the complaint, which has this really strange allegation of 2 different markets, one being the iPhone market, if you will, the smartphone market, the other being the advanced smartphone market. Well, in one, Apple is accused of having a share of 65%, and in the other 70%, 65% being in that borderline, will it, cut it approach. And I'm guessing that when they were looking at courts, they liked the Dentsply reference to 55% if they need to have something to hold up against their alleged 65% share on the part of Apple.
Interesting. So, Steve, what's at stake for Apple? What kind of relief is likely or possible if the Department of Justice wins this case?
I would say that what's at stake for Apple is pretty much everything. Apple has always been about its closed ecosystem. And this is a frontal attack on the closed ecosystem. The requested relief, and we're a long way from what will actually end up being requested were the Justice Department to win and we're at the end of trial. But at least right now, the relief requested in the complaint would ban Apple from what the complaint says is, quote, undermining cross-platform technologies, close quote, which I read as an intention to ask the court to end the closed Apple ecosystem and allow for all of those iPhones that my relatives have to connect more easily with lots of different providers of services that go along with it. And since Apple has been all about the closed ecosystem, if that is ended, well, that helps explain why the share price of Apple has not been doing well in the last couple of months.
Interesting, because I know some people who use Android because they don't like the closed ecosystem. So if Apple gets rid of it, they might even get more customers. Who knows?
I'd be happy to place a bet on that with you, Barry.
Okay. But the closed ecosystem is, it's what distinguishes Apple from its competitors. It's sort of the thing I think people feel strongly about one way or the other. I think a lot of Android users tend to use Android in part because they don't like the closed ecosystem. And then there are people who use Apple because they like the ease with which the Apple products interconnect, and they just find it more user friendly. So in terms of implications for Apple, but maybe also for tech more broadly, is this case going to make it harder for firms to be able to differentiate themselves?
There's no question that if the government wins this case, and that's a big if, I don't think this is any kind of a slam dunk, but if the government wins, it's going to fundamentally change the way that Apple operates. Yes, all of those siblings of mine can remain customers of Apple this and Apple this and Apple that, but they won't have to. And each time something new comes along, there will be a choice to be made. And I think that when you look at the press release coming down here, the government is very much thinking that it's important to break things up. And they're concerned, they say right there, that there's a worry that what's going to happen if they don't get involved is that Apple is going to move over and dominate in the world of finance and move over and dominate in the world of cars and go through more and more of the economy with an Apple-centric world. And they don't like that. And so they're breaking it up intended to preserve and promote innovation in lots of different specters. That will change pretty much everything about how we deal with the world through our smartphones, which is a lot of how we deal with the world.
So, that brings it back to a point that Barry's already raised in terms of innovation, right? And Apple is accusing the government of hindering its ability to design new products and services. And under what circumstances may the government seek to restrict how a business conducts kind of their business dealings, right?
Well, one of the important points to remember is that governments overwhelmingly leave businesses alone. To have an intervention of this kind requires showing both monopoly power or a dangerous probability of changing it and doing something wrong. So for most companies that don't have enough power, they can operate unilaterally doing pretty much what they want, and the government won't get involved wearing its antitrust hat. Maybe its consumer hat or some other hat, but not its antitrust hat. In the world of antitrust, yes, there are limits to what you're allowed to do, but you need to remember that, as you know, there are very few monopoly cases brought, so it's not common for the government to get involved and to intervene. And so most companies, in terms of monopoly behavior, pretty much do what they want.
So, Steve, we've talked about a lot already today, but is there anything else that strikes you as particularly interesting about the case?
One thing we haven't talked about is how incredibly remarkable it is that the government filed this case on top of all the other cases. So you go onto the Justice Department website and look up case data. And if you go look at the 20 most recent years reported, which would 2000 through 2019, in that 20-year period, the Department of Justice filed exactly one monopoly case. Now we're living in an era where the Trump administration, when it was in power, filed a lawsuit against Google, and the Federal Trade Commission filed a lawsuit against Facebook, and the states filed a lawsuit against Facebook, all monopoly cases. Then we talk about the Biden administration. The Biden FTC refiled the case against Facebook and filed a monopoly case against Amazon. The Biden Justice Department filed a second case against Google and has now filed a lawsuit against Apple. The states have filed cases against Google, with cases being led by Texas and by Utah and by Colorado. It's just unprecedented to have this kind of activity in the monopoly space. It's just not happened in my lifetime, and I'm not sure it ever will happen again. So it's really remarkable. In a way, it makes all of this into a bigger deal because the cases to some extent play off each other and amplify each other. On the other hand, it makes the individual cases a smaller deal in terms of antitrust doctrine, because you can have one court deciding the legal issues this way and another court deciding them that way. But it's really a remarkable time in U.S. antitrust history.
Steve, during our closing segment, we typically like to learn a little more about our guest. And with that in mind, I have a question for you. Tell us something about yourself that we would not know if we knew you only in a professional setting.
The thing I would mention would be that one of the publications of which I'm most proud is self-published. You can find it on my LinkedIn page. It is a beginner's guide to classical music concert going, where I set out in a user-friendly way how to go to classical music concerts, when to clap, when to stand up, where musicians sit, how to choose concerts and such. And I have this because there's a new program at the Wayne State Law School this year where every entering first-year student has what's called a sound card, which means that they can go to all 120 concerts at Orchestra Hall here, classical music or pops or jazz or children's or toddlers. They get to go to 120 different concerts for free, bringing along a friend for $5. And it's a program that I dreamed up and am funding, and it's just a thrill to see students connecting with culture and with other parts of Midtown, bringing their mom and dad to hear concerts. It's great fun. But one student said, I'd really like a guide to how to go to a concert. And so now I put on my website up a guide to how to go there. And not everybody knows about that, but I really find it a wonderful thing to see happen.
I'm pretty sure I've been doing it all wrong, but maybe I can put something together for country music. Okay, we have one last, hopefully fun question for you. It's a game we call the Curious Hat.
And now it's time for the Curious Hat.
The game is simple, and the best part is that you can't lose. So I'm going to pull from our virtual hat a random question, and you should answer with the first thing that comes to mind, okay?
All right.
All right, here we go. And I'm going to say this is just a coincidence, this question. On your smartphone, apart from email and work-related apps, what's your favorite app?
My favorite app right now is Shazam, because when you go to a music concert, I'm going to add this to next year's edition of my guide, by the way. When you go to a music concert and the soloist has been persuaded to play an encore, they'll often not introduce the work. And so you don't know what the work is, and you can't go get a recording of it or listen to it again. But Shazam lets you hold up your smartphone and it listens to the music and it will tell you what is being played. And it's just very cool. So that's my favorite app right now.
I think I have that on my Android phone as well. It may be built in. Anyway, Steve, thank you so much for joining us today. It's been wonderful having you as a guest. And to our audience, we look forward to seeing you here next week on our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam. a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.